So non-refundable earnest money. What's interesting is our call volume has gone up. I think last Wednesday I had 47 calls on the legal hotline. And what was interesting, at least 12, I went through and I counted, at least 12 were dealing with non-refundable earnest money, which kind of prompted this legal live that maybe we should cover non-refundable earnest money and what exactly it is. So we're going to go through that. Feel free to type a question if you have one as we're covering the subject. So we'll begin and hopefully cover the things that you want to. So first, Lance, let's start very basic and then we'll kind of work our way up. What exactly is earnest money and what purpose does it serve?
So earnest money, it's basically the first thing that a buyer puts into the contract to say, hey, I'm serious about this contract. And there's a lot of ways you can do that, like we're going to discuss today. But it's basically saying, hey, I'm willing to put this amount of money on the table right now to show how serious I am.
Yeah, exactly. And the Rep C, all of you that are tuning in are very familiar of the earnest money section and how long you have to deposit to deliver earnest money and then deposit earnest money. It's very clear in that section. So yes, and earnest money certainly right now has it's kind of a double-edged sword, right? You put additional earnest money down or a very large amount of earnest money. It shows the seller that you're serious, but that dollar amount may be at risk depending on how you word the contract. So Lance, when you hear the word or the phrase non-refundable earnest money, what exactly comes to mind? When someone says that, what do they mean, non-refundable earnest money?
Well, the first thing that comes to mind is I get a little afraid, just up front, because it's serious, right? What it means is that the money that you're putting on the table that we talked about, there's really very few options to get it back ever. And you choose those options, right? But when you just say this amount of money is non-refundable at this certain time, whenever that is, you're locking yourself in as a buyer, saying whatever else happens, seller's probably going to walk away with that money no matter what.
Yeah, exactly. And so non-refundable right now as the contract currently is written. So let's say you don't do anything, you don't amend any section of the Rep C, there are already references to non-refundable earnest money. So if you look at section 8, for example, we can certainly pull that up. There are instances when earnest money is non-refundable. So we'll just look at due diligence really, really quickly. So if you look at section 8, is or is not, is the property conditioned upon due diligence? And you look at, a buyer's right to cancel, or maybe they don't cancel and they just don't, ask for any sort of repairs or issues. Notice that the very last part of section 8.1C. So if the buyer passes their due diligence deadline and doesn't cancel, it says buyer shall be deemed to have waived the due diligence condition and except as provided in sections 8.2A and 8.3BI, the earnest money deposit shall become non-refundable. So there are already provisions within the Rep C that describe this issue of non-refundable earnest money. So it's not a foreign concept, but the idea of earnest money becoming non-refundable upon acceptance is a relatively new concept. So let's talk very briefly about that. So Lance, when you hear non-refundable earnest money upon acceptance, let's go first. What are some of the pros associated with earnest money becoming non-refundable upon acceptance?
Yeah, I think there's some really big pros to that, right? A listing agent or a seller who sees that on an offer, they're going to say, wow, they're serious about this. And then they're going to look at the amount, and that's going to tell them also how serious they are. And that's a huge pro. They're going to definitely see that as a very strong offer, depending on what else is going on. And that is the biggest pro. That's why people do it, to make their offer get noticed and hopefully get picked, because what happens is that buyer's locked in basically at that point, risking that amount of money for very few reasons they can get it back. So yeah.
Yeah, absolutely. It shows strength in your offer. There's no question about that. Now, some of the cons associated with non-refundable earnest money would be that's at risk, right? For a buyer, that's at risk. So I'm trying to think of ways that could mitigate that risk. One of the things that I've heard other agents do, and something that I've recommended, if possible, I mean, it's obviously a very seller-friendly market to say the least, but to try to get the seller's disclosures before going under contract. If I'm a buyer and I'm putting non-refundable earnest money down upon acceptance, I probably would want at least some basis to know whether or not that's a wise decision or not. I mean, you already understand the risks associated with it, but if you find some significant issues in the seller's disclosures, maybe you reduce the non-refundability portion of the earnest money, or maybe that you factor that in some way. But you would have to work with the seller on getting that before going under contract. Any other pros or cons when it comes to non-refundable earnest money upon acceptance?
Well, yeah, like you said, I've seen some instances where even people sight unseen, they haven't seen the property at all, are putting it down upon acceptance, non-refundable. So anything you can do before acceptance, of course, is going to mitigate some of that risk. Whether that's an open house or seeing the property yourself in some way, or putting something else in the contract. Now we can talk about that later, but yeah, upon acceptance, just know that talking to your buyers is really important in that, and making sure they understand that risk.
Yeah, and I think that's a key component. I had at least 3 calls last week where buyer put in their offer that earnest money would be non-refundable upon acceptance. And we're talking about significant amounts, $5,000, $10,000. So they're risking a decent amount of capital. And after going under contract for a day or two, buyer cancels, right? And then they say, "Oh, buyer's agent, you take care of it." And ultimately the buyer's now looking at the buyer's agent to say, "Hey, did you warn me about this?" Or "I didn't realize the import of earnest money," or "I didn't realize that earnest money, when you said non-refundable, actually meant that it was non-refundable." So as buyer's agents, as you're writing these offers, please stress to your buyers exactly what it means when it's talking about non-refundable earnest money. I know it's somewhat of a foreign concept for many buyer's agents now, that earnest money, there's always a way to get it back based on the REPSI. But right now, how they're being drafted, it's something that is, you have to be very definitive with buyers, because they may have buyer's remorse, and they need to understand the impact of what the contractual language means. Because once the seller accepts, that's what the two parties have agreed to. And so any sort of deviation from that's gonna require the seller to acquiesce on that point.
Yeah, and some of these buyers might be thinking, they're canceling 1 or 2 days after acceptance and before they actually give the earnest money to their agent. So that could be a misunderstanding on their point, or the buyer's agent isn't explaining that, hey, the timing here doesn't really matter if we've said upon acceptance. It's not upon receipt of the earnest money or any other kind of condition you could write in there.
Yeah. So there are a couple of points I want to address these. I think any sort of question or comment would be appropriate regarding earnest money. So feel free to chime in. Rob writes, if there is non-refundable earnest money and seller takes it, is that considered liquidated damages? And then the seller cannot go after the buyer for additional damages. So I think I understand your question, Rob. So there is a section in 8.3b that talks about liquidated damages for a seller. and how they agree that's going to be the sole remedy for a seller. So my answer to you, Rob, is going to be an attorney answer. It depends. It depends, I think, on a couple of things. One is 8.3, does it require financing? If it requires financing, then all the sections below 8.3 are going to apply, which also includes, you'll see right here, earnest money deposits, and how that's the sole or exclusive remedy for a seller. Now, if the financing condition is not part of the contract, then that exclusive remedy aspect doesn't apply. So I think it really kind of warrants, what is there a condition of purchase? And I would think a lot of offers do have financing as a condition of purchase, but not always. So I think in that instance, it's going to depend on exactly what does the contract say. But certainly that is where it's being held, or if it's been released prior to settlement or closing, the contract doesn't say that invalidates a seller's remedy. And so I don't think it does. I think it really does depend on whether or not the financing condition is part of the contract. Okay, Allison, I'll let you, Lance. So many agents are writing offers that a portion or all of the earnest money is non-refundable upon acceptance, but then also writing that should buyer cancel the contract, their earnest money shall be refundable. So what would control in a situation like that, where maybe in the same addendum, they're writing earnest money non-refundable, but then if a buyer cancels, it's refundable? How would you try to decipher that?
Yeah, so that is gonna should be a huge red flag, right? Both agents should be reading that language carefully, and that's kind of the definition of an unclear addendum where the contract is saying two things that directly conflict with one another. So a lot of times those will just fall out, like there's no agreement on what will happen potentially, but you're going to have an argument for sure. So if you can read through that and prepare to write something a little more clear or respond to that instead of arguing about it later. If they're in the same addendum, I mean, timing can come into effect, but usually they're just going to conflict against each other and they're not going to mean very much.
Yeah, and at that point, if I'm the seller and I'm reviewing these offers and there's language like this where it says non-refundable, but then refundable if you cancel, I would want to clarify through a subsequent addendum. At that point, I would counter if I were the seller, because when you have conflicting, ambiguous language, even if the buyer's agent is telling you this is how I interpret it, that interpretation may change 2-3 weeks down the road. And I've had a number of hotline calls where that's been the case. And so we really want to avoid any sort of ambiguity as soon as possible. And that's as you're forming the contract. So if you see agents writing that, I would say, look, make a decision. It's either one or the other, right? It's either non-refundable or it's refundable, right? So, I mean, just make it as clear as possible. So that's a good point about contractual drafting. Ellen mentions, do you think we should have something in writing, even if it's just an email, so that the agent can show that they've explained? So I think what Ellen's talking about is explaining to the buyer maybe the ramifications of non-refundable earnest money. What would be the best way to explain it to them? Would it be verbally, in writing? How can you show that you've met your fiduciary duty of reasonable care?
Yeah, I think both of those are great ideas, right? The more we can explain, and of course to cover your back, when you can prove what you've explained to them, is always going to be helpful for sure. So I don't think that's a bad idea at all.
Yeah, and Ellen, it could be, you explain it to them verbally, explain to them kind of the ramifications, and then it could be potentially an follow-up email memorializing exactly what you discussed, just to show that, look, you're looking out for your client's best interest, but ultimately, if your client chooses to write an offer like this, it's under their own volition, and they're doing so understanding in many instances that it may be a requirement to get an offer. accepted by a seller, just because many offers do include some sort of non-refundable earnest money. Not all of them, but it is something, as Lance stated at the beginning, a way to strengthen an offer. And again, sellers market, they may want to dictate those types of terms.
And I've seen some of these clarifications in the contract themselves, right, where they say earnest money is non-refundable, which means if this contract is canceled for any reason besides like a seller default, and this is all in the addendum, then seller will take the earnest money and it will be released to him. It explains exactly what happens. They're signing off on that instead of just saying, this is a non-refundable, having it 2 or 3 words. It goes into a little more detail what that means.
Yeah, I love that because, you'll notice in section 8.1 specifically, we'll just use that as an example, where there's a deadline, buyer has a right to cancel, and it clearly outlines exactly what happens if the buyer cancels by the deadline, right? It says that the earnest money shall be released to the buyer without, any further written authorization from the seller. And it's spelled out as clearly as possible. And so when you're drafting addenda, especially when it comes to earnest money, especially when your language may have impacts on previous iterations of the Rep C, I would spell it out as clearly as possible. Even as basic as possible. It should be understandable and clear to both sides so that there's no dual interpretation of the contractual language. So I can't stress that enough. Make it as clear as possible. If you want it to go in a different location, if the seller wants it released upon acceptance to them directly, it's got to say so. Otherwise, the boilerplate language of the Rep C is going to control. And when you have maybe these dual interpretations, that's where not only the parties get in trouble, but also the respective brokerages have some potential liability as well. Rob, yes, it is part of a class that we have to say it depends. As an attorney, they drill that in, right? You have to say that because we don't have all the facts, right? So it certainly depends on a couple of nuanced situations. We would love to give black and white answers that have no gray area in them, but very often litigation arises because we have gray area, right? And dual interpretation. So it's a good point. Yes, we do say that purposefully. Audrey has a question. So if earnest money is non-refundable and significant repairs come up after going under contract, do the sellers have any obligations to fix those necessary repairs or wanted repairs, either way?
No, I'd say no. They have no obligation to agree to anything more in the contract ever, right? So they can negotiate that for sure, but no.
Yeah, exactly. If the buyer's gone under contract and they find things during due diligence, they can ask for contractual modifications, which could be, a reduction of purchase price or reducing their earnest money or whatever they want it to be, or asking for repairs, but it would require the seller to agree to them. We could get a little more nuanced with that. So what if the seller concealed something or failed to disclose something? Then there's a potential breach of contract or a fraudulent representation, and that's going to be a different claim, which kind of segues into a good question that we've had recently on the hotline is, well, if I make my earnest money non-refundable, Lance, and let's say the seller cancels because they can't find a replacement property, and they are in breach of contract, so they don't have a right to cancel. What happens to the earnest money at that point?
Yeah, that's a great question. This comes up actually more often than you'd think, probably. And first, I'd say, along with your when you write the actual language, it doesn't hurt to add clarifying language that says, you'll get the earnest money back, or the seller will get it no matter what if it's canceled, except in a seller default. Something like that clarifies. But I think even without that language, the contract already, as Craig pointed out, has earnest money going non-refundable in certain situations. And still there's section 16 that gives remedies to a seller default. So I still think you have a good argument for sure to get, even if it says non-refundable, that you can get that money back with a seller default. But I did do some research into this with other states, and I've seen courts not interpret it that exactly. Now that's not in Utah, not with our contract, but the clearer we can be, the better for sure.
Yeah, exactly. So, and you'll, again, if we refer back to when in a normal market, when buyer has, a variety of conditions of purchase and they pass that last condition, usually it's financing or appraisal, earnest money is non-refundable at that point in most contracts as it's currently constructed. But you'll notice that it doesn't modify the remedies found in Section 16. So, for example, if a seller defaulted, one of the remedies available to a buyer is that they cancel the contract, they get their earnest money back, and they would get a sum equal to it. So in that instance, even though the earnest money may be non-refundable because they've passed all their deadlines, there still is a remedy available for a buyer in the event of a seller default. So I just want to emphasize that there is that safeguard. I've had some agents express, well, I don't like non-refundable earnest money because what happens if the seller cancels? Do they get to keep the buyer's earnest money even though the seller failed to perform? And I would say no. I would say that the buyer has a very good argument to point to a specific provision in the REPC to say, no, it should be released back to me. Allison says agents need more guidance from their brokers prior to writing these addenda. And thank you, Craig and Lance. Well, you're welcome. And yeah, definitely, if you're going to get creative with language, having another pair of eyes, especially one that has experience, is always a good thing. I definitely would suggest that. Rob makes a comment, when we get convoluted terms, we simply counter that says 8.1, 8.2, and 8.3 are in the affirmative, and the buyer has 1 day for loan appraisal and inspection. So yeah, there's a number of ways to handle how you want to counter if you're a seller, and ways to make it more clear when it comes to non-refundable earnest money. Stacy has I think a good question. I've had this question a couple of times, and maybe Lance will answer it with the phrase "it depends." So we'll couch it with that. But she says, if addendum number 1 says earnest money is non-refundable, and I assume upon acceptance or something like that, but addendum number 2 is the FHA VA loan addendum, is it truly non-refundable?
Yeah, I think we've had this question a lot in different forms and a lot of discussion about, unintended consequences when we're not being careful a lot of ways. But yeah, that form is going to probably override anything that came before it, right? So it says no penalties for backing out or something like that. So yeah, it probably would override that. And yeah, that comes up sometimes, but that's, I think, the general interpretation of it.
Yeah, and let me show you something as to why I agree with Lance. So when we look at the FHA VA loan addendum, I think to Stacy's point, if you look at number 3, it says notwithstanding the financing and appraisal deadline, if applicable, so maybe there isn't a deadline, buyer shall not be obligated to complete the purchase or incur any penalty or forfeiture of the earnest money deposit. Now it's tied to a very specific, phrase. It's going to be tied to the appraised value versus the purchase price. But it's very clear that the earnest money is not to be forfeited. And to Lance's point, the order of the addenda really does matter, because look at this, and this is boilerplate language on every addendum, including the UAR addenda. It says, to the extent the terms of this addendum modify or conflict with any provisions of the REPC, including all prior addenda and counteroffers, these terms shall control. And then if it's not modified, then the remaining terms stay intact. So, with Stacy's question, well, if I say earnest money is non-refundable, but then addendum number 2 has this language that says shall not be obligated and will, it doesn't incur any penalty or forfeiture of earnest money, and you read that with this additional language, yeah, I think a buyer has a really good argument that if the appraisal comes in low, they have a right to cancel and still get their earnest money. So with that being said, as a seller and as a listing agent, I would want to clarify that through a subsequent addendum. If earnest money is really going to be non-refundable, clarify it. Make it clear, which provision is going to control, because, it may seem clear to everyone at the start, but then you start to get dual interpretations as the transaction proceeds. So just be very mindful of that. I think that's a great question, Stacy. Okay. Rob mentions, releasing it up front is dangerous. What if the seller defaults? Yeah, that's a real risk. The seller defaults, then, hopefully you have language that says that the buyer can claw after it, and certainly they would have a legal remedy. But yeah, you then lose control over how it's dispersed. That's a fair point. And some would say, the same thing. If a buyer defaults, how does the seller get the earn? I mean, so there's kind of balancing with that, but yes, it has a real cost to a buyer in that instance. Okay. Excellent questions. I can tell that this is a very pertinent topic just based on the comments, trying to reach them all, just making sure. Okay. So here's an additional question. So related but unrelated. This is from Ellen. I recently received a few offers on a listing that the buyer's agent checked 8.2 as is not conditioned upon appraisal, but then in the addendum stated buyer to pay blank number of dollars above the appraisal. One of them included wording that stipulated if the appraisal was below purchase price. One did not clarify. Anyway, is that a direct conflict or not? Okay, so yeah, that is a little unrelated, but that's a relevant question. So I think I understand. So you have an offer where there's not an appraisal condition, but then there's an addendum that says buyer will pay X number of dollars, maybe $5,000, $10,000 above the appraised value. Is that a conflict? And, maybe I can answer that and get your thoughts as well. One, I don't think it's a conflict simply because you're removing the condition, but they're stating that they're willing to pay above they're giving you some sort of declaration. Hopefully that language is clear. So if it's meant to modify the purchase price, then it needs to say so. If it doesn't modify the purchase price, then I'd say the purchase price is more than likely going to stay the same no matter what the appraised value is. So it's probably meant to give your seller some assurances that this buyer is serious and really wants to move forward. You didn't mention if there were financing conditions as part of this, but that certainly could impact whether or not a buyer has a right to cancel in those instances. Lastly, I would say you may want to counter with maybe the UAR appraisal addendum. I've seen sellers start to do that so that it's clear. Look, purchase price doesn't change, but buyer's willing to give some assurances. And if 8.2 doesn't apply, then there won't be a right to cancel anyways if there is a low appraisal. Lance, any additional thoughts on that?
No, I guess sometimes there's confusion about maybe if they're removing the appraisal condition, can they still do an appraisal or something like that? And I would say, yeah, they probably do. If they have a due diligence condition, anything they want to do with the property, almost they can do under something like that. But yeah, I totally agree.
Yeah, that's a good point. I'm glad you brought that up, Lance. So many offers now I've seen are removing due diligence as a condition of purchase, removing appraisal as a condition of purchase. And if you're removing those conditions, you'll notice in section 8.1, for example, let me pull that up. You can tell I like 8.1 just because it's easy to kind of refer to. So if you look at 8.1, if you look at 8.1, it talks about is or is not a condition of purchase, right? So you have there, if checked in the affirmative section, then 8.1A through C apply. Otherwise, they do not. And so that's the right to inspect the property is under 8.1A, and then the right to cancel. And then you could certainly waive your right to cancel if you pass the deadline. If you don't have a due diligence condition, I'd say by default, you don't have a right to inspect the property. Now, you could certainly build that in saying, look, buyer still wants a right to inspect the property and seller agrees to cooperate, but there is no right to cancel based on due diligence items. But you're going to have to preserve that because there may be, I can't think of many instances, but there may be instances where a seller doesn't want a buyer to do an inspection. Or kind of like how you brought up, is or is not the appraisal condition. If it's not checked in the affirmative, then 8.2A and 8.2B, they don't apply. They only apply if there is an appraisal condition. So that's a good point. I mean, we kind of think, oh, I'll still have a right to inspect, or I'll still have a right to get an appraisal. It really depends on the language. Right now, if those are conditions of purchase, then you do. But if you don't include that, then I'd say you don't, unless you can work something out with the seller, which again, most sellers I would think would say, yeah, that's fine. You don't have a right to cancel. So why do I care? Right. So, just work that out. Just don't assume that you can do something. Okay. Excellent comments. Appreciate the participation. I understand that it's a hot market out there, and we definitely want to be receptive and responsive. Please feel free to give the legal hotline a call. If you do have any sort of questions, feel free to let us know if there are other topics you'd like us to go over, or if you'd like to do this one again and maybe cover it in some other nuanced details. But definitely want to highlight things that are relevant to you. Many of the things that we cover are just based on what we get on the hotline. So definitely chime in with us. Lance, appreciate your participation today. Great explanations. If you do have any additional questions, feel free to chat in there, and we'll definitely look to help you out with those. Until next time, thanks for tuning in. Take care.